Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Jurisprudence class. We are going to discuss an important case law on the reasonableness. This is basically actually very landmark judgment. Air India etc. versus Nargesh Mirza 1981. Actually, this is a landmark judgment in Indian equality jurisprudence, basing on Article 15, Clause 1 and Article 16, Clause 2 of the Constitution of India. Otherwise, we can call it as a sex determination or sex discrimination case. So many important points are there. Reasonableness is 100% discussed thoroughly by Honorable Justice Fazlullah in this case. Right. So here, the main context is regarding actually this Nargesh Mirza. She was working as an air hostess. Air India, of course, they have formulated their rules and regulations regarding the employment, the service and the termination or resignation of the employees. The conditions of the employment, particularly rule number 46 and rule number 47, or they call it as regulation. 46 and 47 say that an air hostess, normally air hostess will be women. An air hostess has to retire after getting first pregnancy. I am telling in the reverse manner. Normally point number 1 is different. This is point 3. She has to resign after getting first pregnancy. Second point. The air hostess, if at all she is married, so she has to get retirement within first 4 years of service. Of course, she gets pregnancy, finish. Within first pregnancy, she has to retire. So even though she is married, then she can continue up to 4 years if she doesn't get married. And please remember, the third most important one. So the woman, the flight attendant, on reaching 35 years of age, she has to retire. And the discrimination is given to the airport director to extend the age for 10 years more. And as regards the flight pursuers, for the males, the retirement age is 58 years, but for the females, it's only 50. So here, all these things, definitely, they lead to discrimination. They lead to the difference between sex and gender. Suppose if it is males, he can continue up to 58 years. If it is a female, she has to drop down at 50. If it is a female, she has air hostess, then only 35 years of age. Is it not discrimination? Then this woman, Nargesh Mirza, she contested the matter. She filed a petition stating that this discrimination should go away. Very beautiful point she has raised. Of course, you have to know the defense also. Is it not? Air India, definitely, you know, it's a commercial organization. It's a business enterprise. Is it not? No doubt, they are taking persons from one country to the other country, but on taking money. So, their conditions say that duty and youth and as well as glamour, they are the part of the in-flight service. So, the woman who acting as an air hostess, she should look beautiful, not beautiful. She should have the young looks, at the same time she has to maintain glamour. You may be saying day in and day out, whenever you are going on flight, you may be seeing the air hostess with a clean makeup and with the very good culture, behavior, all these things. Why? Because the business should go on properly. The tourists should be actually should be attracted, not in the other manner, not sexual attraction. This is attraction means looks quite neat. So please remember, and these points, they were discussed at high level. Even the matter has come to the Supreme Court. Supreme Court clearly stated that the rule of pregnancy is highly unreasonable. Why? Suppose if a poor woman is there, poor air hostess is there, suppose she has to maintain the family. Definitely she will be afraid. If she gets pregnancy, she will be relieved of the job. Then what to do? Then she will see that pregnancy does not come. She may go for abortion. That possibility is also there. Second, for the flight purses, the male people, the age is 58 and the same nature of job is being done by the so-called women also. Then why the discrimination particularly the age? Beauty. Is it given? It's given by God. Some people, even though they are black in color, they are beautiful, photogenic faces. Some people, even they are white in color, they are pale looking. They don't have any glamour. So this is not to be decided by the Air India. So therefore, rule numbers 46 and 47 of pregnancy and marriage conditions, they are highly unreasonable. So it is against to the spirit of the Constitution. There is Article 14, equality before law and equal protection of laws. And please remember Article 15, Clause 1, discrimination on the grounds of sex. Is it not? So even though Air India argued that a woman's role is like that, she has to look beautiful, and on occasion during arguments it is also stated that woman is only a family planning vessel. They are totally curtailed, they are totally denied by the Honorable Supreme Court of India. So in this connection, therefore, I am telling you, constitutional jurisprudence. A constitutional jurisprudence was launched by the Nargesh Mirza case, where the rules of service, they should not dominate the so-called conventional or the constitutional ethos. So therefore, the primacy should be given, equality should be given to both the genders. So very good case law. So test of reasonability 100% applied here. So దీంట్లో మూడే పాయింట్లు. ఒకటి, ఆడవాళ్ళకి ఎయిర్ హోస్టెస్లకి ఎయిర్ హోస్టెస్కి 35 ఏళ్ళు వస్తే రిటైర్ అయిపోవాలి. అలాగే మ్యారేజ్ చేసుకుంటే ప్రెగ్నెన్సీ వస్తే ఫస్ట్ ప్రెగ్నెన్సీతో రిజైన్ చేయాలి. ప్రెగ్నెన్సీ రాకపోయినా 4 ఏళ్ల లోపల రిజైన్ చేయాలి. అదే మగవాళ్ళు అయితే దే కెన్ కంటిన్యూ. ఫ్లైట్ పర్సన్స్ అంటారు వాళ్ళది. సో వాళ్ళది 58 వరకు ఉండొచ్చు. ఆడవాళ్ళు అయితే 50కే రిటైర్ అవ్వాలి. These are all complicated issues. No equality. No doubt Air India, వాళ్ళ బిజినెస్ పరంగా ఆలోచిస్తే వాళ్ళది కూడా కరెక్టే. బట్ ఎనీవే, సో ఇట్ ఈస్ డెఫినెట్లీ ఈక్వాలిటీ బిఫోర్ లా లేదు కాబట్టి టోటల్లీ హెల్డ్ టు బి irrational and unreasonable by the Honorable Supreme Court of India. If you know this much is sufficient. Thank you very much. Please remember, it is a landmark case in Indian equality jurisprudence. Thank you.